the necessary and proper clause may mean other things, even if you're right. But so in light of what you've said, your answer to Justice Barrett's questions is yes, right? They can be held liable whether they know, whether they don't know, quite across the board.
For government officials, yes. As to the hypos, I think that one of Justice Gorsuch's hypos, which Justice Barrett followed, might have included private parties. The government doesn't take a position as to how this would cash out in terms of private parties. I think, as Petitioner's Counsel noted, I think there's obviously different issues of consent, especially when we're talking about reaching a member of the general public. But in terms of reaching government employees and agents, we think that they can clearly be reached. I do agree with him that.
So even though we require pretty express consent by the state before they're bound under the spending clause, we don't require that with respect to the individuals.
Your Honor, no. I think what matters for purposes of the spending clause is clear notice to the states who accepted funds. And again, this isn't surprising to individual officers.
So you're saying, does the same standard apply to the individual employees?
No, I do not think under the spending clause that they need to have clear notice.
That's